So, what happens when a simple safety concern in your own home turns into an all out legal battle with your homeowners association? We're going to dig into the story of one resident in a luxury condo building who started asking a few too many questions for his HOA's comfort and ended up uncovering major security and financial risks. It sparked a huge fight for just basic accountability. Let's get into it.
And really, it all kicked off with this. This is the moment resident Keith Cunningham realized the problem was way more serious than he ever could have imagined. A building employee, someone with a key, with access to everything, had a deeply disturbing criminal past. This wasn't some little grievance. This was a serious potential threat. Literally feet from his own front door.
Okay, so let's rewind to June of 2023. Keith Cunningham and his wife noticed some, let's call it unbecoming behavior from a night security employee. But when they brought their concerns to the HOA board, they were just dismissed, accused of harassing the board and just trying to cause trouble. That didn't just sit right with them. It was a massive red flag. So they decided to do their own digging. And what they found was, well, it was shocking. It wasn't just one employee. Get this, another one was arrested on felony charges involving children. And then came the real bombshell. The board had just stopped performing background checks on staff altogether. But it gets even crazier. One employee had a prior assault charge inside the building, and when the police asked for the video footage, the HOA actually refused. I mean, come on. This wasn't a simple mistake. It was a clear pattern of dangerous negligence. So, faced with these massive safety failures, Cunningham knew he had to figure out how in the world this could happen. And that meant one thing. He needed to see the records, specifically the contracts with the security vendors.
And, legally, he was on totally solid ground. In Arizona, this statute is super clear. An HOA has 10 business days to make its records reasonably available for a member to look at. It's a fundamental right for a homeowner. 10 business days. Remember that number, because it's going to be important.
But what should have taken, 10 days, well, it turned into this months-long nightmare. He makes the request on July 10th. Then, on the very last day, day 10, the HOA's lawyers finally respond, saying, oh, it's all online. Spoiler, it wasn't. So he goes to an in-person review in August, has to take a day off work, and guess what? The documents are still missing. Fast forward to late September. We're talking months later, and they're still just trickling in partial information. And here's the absolute kicker. This is an email from the HOA's own attorney. After weeks of stonewalling, she admits, yeah, I couldn't find the contracts on the portal either. And the reason? Get this. An internal switch just needed to be clicked. I mean, you can't make this stuff up. This was the proof right here. Cunningham wasn't being difficult. The information was literally being hidden from him. This really set the stage for two totally competing narratives. On one side, you have Cunningham, who's just trying to protect his family from what he saw as gross negligence. And on the other side, you have the HOA claiming he was weaponizing the law just to punish a volunteer board. So was it a shield or a sword? That was the big question. But believe it or not, the whole fight over the records, that was just the beginning. As Cunningham finally started getting his hands on some of these documents, he stumbled upon an even bigger problem, one that put every single resident's financial future at risk. Okay, so to get this next part, we need to talk about something called CC&Rs. Just think of these as the constitution for the HOA. They're a legally binding contract. The board can't just make up the rules as they go. They are legally required to follow what's written down in this document, period. So here's the first thing Cunningham found. The CC&Rs, the official rulebook, said they needed a general liability policy of at least $3 million per occurrence, but their actual policy? Only $1 million. Now, the HOA tried to argue that a separate umbrella policy covered the gap, but the fact is, the main policy was in direct violation of their own legal documents. But the other insurance failure? Whew, boy, it was even bigger. The CC&Rs also required the property insurance to cover 100% of the building's appraised replacement value. Okay, makes sense. An appraisal from 2022 valued the building at $73 million, but the insurance policy they actually had, only $59 million. So do the math. That's a $14 million shortfall. Just think about that for a second. If there was a major fire or a flood that destroyed the building, the residents themselves could be on the hook for that $14 million gap. all because the board wasn't following its own rules. That is a homeowner's absolute worst nightmare.
So how did something like this even happen? Well, at the hearing, the HOA board president, Mark Temin, gave this incredibly honest testimony. He just flat out admitted he didn't even know the 100% coverage rule was in the CC&Rs. His words were, "That was my bad." I mean, it's an honest admission, but wow, a stunning oversight for such a critical responsibility.
Okay, so with all of this on the table, the records being stonewalled, the multi-million-dollar insurance gaps, the whole thing went to a formal administrative hearing in front of a judge. And it really boiled down to this. Cunningham's side was pretty simple. The law says 10 days for records, you broke it. Your rules demand specific insurance, you ignored them. The association's defense was basically, hey, we tried our best with the records, and the insurance thing was just an honest mistake that we fix now. So who was right? So all the evidence was in, all the testimony was heard, and all that was left was for the judge to make a decision. After months of this guy fighting for just basic transparency and for them to follow the rules, what would the judge decide? The answer? It was simple, and it was decisive. In a written order, the judge ruled completely in favor of the residents. A total, complete victory. And the judge's order was a total clean sweep. First, the HOA had to pay Cunningham back his $1,000 filing fee. Second, they were officially ordered to comply with the state's records request law from now on. And third, they were ordered to follow their own insurance rules. The message couldn't have been clearer. Follow the law and follow your own rulebook. So, what's the big takeaway from all this? Well, this whole story is a really powerful reminder for any homeowner out there. Those CC&Rs, they aren't just suggestions, they're a binding contract. You have a legal right to see your association's records. And maybe the most important lesson here is that one persistent person, armed with the facts, can actually force their leadership to be accountable. And that really brings us to the final, crucial question, doesn't it? This entire saga started because one resident just felt like something wasn't right and decided to actually check the paperwork. It really makes you wonder, do you really know what's in your HOA's records?